Resuming debate, the honourable member for St. John's East.
Thank you, Mr. Speaker, and I'll be sharing my time with the member from Winnipeg Centre. Mr. Speaker, I'm pleased to stand today on Bill S-3 and would like to acknowledge first and foremost that I do so on the traditional territory of the Algonquin people. The government has always been clear that it is committed to removing all sex-based discrimination from registration provisions of the Indian Act. With the government amendment which was passed by the Senate, Bill S-3 will remove all sex-based inequities from the registration provisions of the Act. The government is also committed to doing this in a way that is the right way, and as such it will be launching broad-based consultations next year on Indian Act registration and membership reform. This will include extensive consultations on identifying any unintended consequences of the 1951 Cutoff Amendment and working in partnership to develop solutions to eliminate or mitigate any concerns by First Nations peoples. While the balance of the bill will be brought into force immediately, the proposed clause regarding 1951 cutoff will be brought into force after those consultations and once a comprehensive plan to address the identified issues is developed in partnership so that it can be implemented simultaneously. Senator Christmas, a senator of Mi'kmaq heritage from Nova Scotia, summarized the issue during his speech in the other place on November 8th, and let me quote, "Throughout the consultation that is to occur, the government will need to be attendant to the voices of these communities. There will be a myriad of factors impacting the communities, flowing from the numbers of those who will receive status, dealing with issues going beyond the matter of gender. I recall the last time efforts were made to address gender discrimination in the Indian Act in 1985. I can tell you with absolute certainty that my community experienced confusion, felt concern, and had a great deal of questions about the process and its impacts, both short-term and long-term. It's a complicated matter for First Nations bands. It will take time, cooperation, and assistance in enhancing capacity to make the significant transition both manageable and sustainable. Effective consultation in this regard is critical. The government needs to be certain it is prepared to go before our First Nation band councils to explain this bill's provisions to leadership, to band members, and to those who will ultimately receive status as a consequence of the bill's passage." End quote. The government is absolutely committed to dealing with all sex-based discriminations in Indian Act registration, including circumstances that date before 1951. By convention, a government does not put into any provision, into any act or law, any provision they do not intend in good faith to implement, and as such, this amendment is a clear and unequivocal statement of the government's commitment to remove the 1951 cutoff. Consultations will be focused on identifying additional measures or resources required to do this right and working in partnership to develop a comprehensive plan which can be implemented simultaneously. As Senator Sinclair, chair of the Indian Residential Schools Truth and Reconciliation Commission, noted in his speech in the other place on November 8th, and I quote, "I want to point out that this bill attempts to reconcile two different constitutional obligations that the government has. One is, of course, to comply with the Charter when it comes to gender discrimination, and the other is to comply with its constitutional obligation to consult with Indigenous peoples." End quote. He went on to say later in his speech, and I quote, "So while it is with reluctance that I see us delaying the implementation of a charter right, I can also see the need to do so because of that competing constitutional obligation to consult. And so I'm prepared to support this legislation because it enshrines the right." End quote. And in a way, it enshrines both rights, both the right to be consulted and, of course, their charter rights to not be discriminated on the basis of gender. Given the government's commitment to co-designing consultations with First Nations, it will not accept the addition of a specific coming into force date to the proposed 1951 cutoff clause. That would be counterproductive to the nation-to-nation relationship. Senator Christmas also spoke in the Senate on November 9th, saying, and I quote, "For those who might suggest the lack of a firm date for coming into force provisions is a weakness or flaw in this undertaking, I would assert otherwise. The reporting to Parliament provisions in the bill more than adequately deal with this in my mind. I believe it is also essential to recognize that the consultation with First Nation communities that will flow from the bill's requirements on consultation and reporting back to Parliament reflect the basis of the principles respecting the Government of Canada's relationship with Indigenous peoples announced in July of 2017. End quote. The bill contains numerous clauses holding the government accountable to Parliament regarding the implementation of this legislation. Bill S-3 requires consultations on implementation of the clause in question, as well as broader Indian Act registration and membership reform to commence within 6 months of royal assent. I understand these consultations are actually expected to commence early in 2018, and the co-design of these consultations with First Nations is already underway. Within 5 months of royal assent, the government is required to report to Parliament on the design of the consultations and how they are progressing, and provide a further update to Parliament within 12 months of royal assent. There is also now a 3-year review clause in the bill. Parliament will have numerous enshrined opportunities to hold the government to account on its progress towards removing the 1951 cutoff. In terms of how long consultations will take, the government will not prejudge the co-design process, but it is committed to working with its process to move forward in an expeditious manner. If we do not have legislation passed before December 22nd, which addresses the Descheneaux decision, the section struck down by the court will be inoperative in Quebec, and based on the most recent extension decision of the Court of Appeal, it is unlikely the courts will grant a further extension. The registrar has stated that she would not be in a position to register people under provision found to be non-charter compliant in Quebec, and would also not register individuals under those provisions in the rest of Canada. 90% of status Indians are registered under provisions struck down by the Descheneaux decision. We must not lose sight of the thousands of individuals who will not be able to register if the court deadline passes and the provisions noted above become inoperable. I urge members of the House to support Bill S-3. I'm glad to hear members of the opposition are in support of it in the form that was referred to the House by the Senate. Thank you, Mr. Speaker.
Questions and comments. The honourable member for Peace River Westlaw.
Thank you, Mr. Speaker. I know that my honourable colleague there started off with talking about the consultations that are going to be taking place for the next phases of this particular bill. Mr. Speaker, I was just wondering a little bit about the principle behind these consultations. I know that it seems really like if the government wants to drag its feet on something, if the government's trying to delay something or prevent something from happening, they go into consultations. But if they're adamant about getting something done, if they want to make a big flashy announcement in New York, for example, they have no problem making these announcements with zero consultation. I'm referencing in particular the northern drilling ban, of which the Nunavut Premier and the Northwest Territories Premier were both given less than 45 minutes notice that this announcement was coming down. Then, when the government discovers that, lo and behold, they have forgotten to do the consultation on this particular announcement, they've said, oh, we've made the announcement and now we're going to do the consultation. So I was just wondering if the member could outline for us the principles behind their desires to do consultations and whether it is just a stalling tactic. Thank you, Mr. Speaker.
The honourable member for St. John East.
Thank you, Mr. Speaker. And I hear the member and hear his concerns regarding this, but when I look at the legislation, when I look at our honest, good faith efforts to consult with Indigenous peoples to ensure that their rights are respected, not only in their charter rights, but also in the manner and the process by which their charter rights are invoked and protected, the manner by which people will be registered into their bands and any unintended consequences that may result as a result of those changes in registration, I feel that the government is moving in the right direction. The Senate amendments, which have the support of Senator Sinclair as well as Senator Christmas, give me great comfort that this is going about in the right way. But I do understand that if there's a delay in the process, it will affect thousands of individuals who have a right to be registered. And this is why I'm also so pleased to see in the legislation defined timelines by which Parliament is going to be told about what is happening, that there will be metrics in place to make sure that the bill is reviewed at 5, 6, 12, and 3 months and 3 years. So that gives me great confidence. Thank you, Mr. Speaker.
Questions and comments. The honourable member for Kitchener South Hespeler.
Thank you, Mr. Speaker, and I want to thank my colleague for his great speech. He quoted Senator Christmas, and he said that the government will need to pay close attention to Indigenous communities. And I just wanted to ask the honourable member about the importance of consulting and how that process needs to be done efficiently and effectively, and how we can, after the consultations, make great efforts to ensure that we have proper policies put forward.
The honourable member for St. John's East.
I thank my good colleague here sitting next to me on this side of the House. I think it's important to remember that the very design of the consultation process needs to be done in connection with Indigenous people, and that's why the process itself is co-designed. Without this, I think people would rightly feel that the process was being dictated, that people's views were not appropriately being taken into account, and that a true nation-to-nation relationship did not exist. So the co-design is a very important feature. What comes into the co-design is not for me to decide. It's something that First Nations people and the government will negotiate. I look forward to seeing a robust process that allows voices to be heard, all possible implementation issues and unintended consequences to be vetted, and then a strong process with respects everyone's charter rights being implemented as soon as possible so that Indigenous people can be registered without sex and gender discrimination. Thank you, Mr. Speaker.
Questions and comments. The honourable member for Nanaimo Ladysmith. It'll be a 30-second question and a 30-second answer, please.
Thank you, Mr. Speaker. I'm hoping that the member, representative of the Liberal government, can square his government's commitment to hear all voices with the fact that last week the Liberal majority at the Indigenous Affairs Committee blocked a motion to hear from Privy Council office witnesses on how they're handling money for the Murdered and Missing Indigenous Women's Committee or inquiry. And then today in Status of Women Committee, we learned that INAC has declined our request to participate in Status of Women Committee's study on Indigenous women's experience in the justice system. Can you please reconcile those hypocrisies?
The honourable member for St. John's East, but I just want to remind the honourable members to direct their questions through the Speaker, not directly to the other member of Parliament. The honourable member.
Thank you, Mr. Speaker, and I do appreciate that all committees are masters of their own domain and can determine whether or not or how or when they will receive witnesses, but I am confident that the process being proposed under this legislation will allow Indigenous communities and the government to work together to co-design a process that will allow the people that both groups agree can come before their respective committee or within their process to be heard, and so that good decisions can be made. But obviously it wouldn't be up to the committee, either INAC or any other. It's going to be something that's decided between First Nations and the government. Thank you, Mr. Speaker.